This one really
I had a summer's last week which like
I'm gonna go fill this up.
we're waiting for you, It's good to see you.
Want something, we just have to do this like this, and he'll be like, oh, gosh, this is been.
Court back in session, remain seated and come.
Afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
I'm not standing because of your entrance, because I was asked to stay seated. I'm standing to address the court about the next matter to be heard.
Okay.
State has been served with a notice of a motion to continue the matter for trial, and the state would like to be heard at the appropriate time.
Okay. Why don't I hear from defense on that first?
Yes, sir, Your Honor. Thank you. As is clear from the testimony we heard this morning before the lunch break, we're dealing with an offense date of July 19th, 2015. The outline that I've just prepared for my motion to continue, it appears that the indictments were returned September 28, 2015. The discovery, the date that I have, the crash reconstruction report that was ultimately compiled, mainly by Trooper Trueblood that testified earlier, that was given to us by the DA's office here on February 25th of 2016. On March the 21st of 2016, we had what I think we referred to as a status conference. It was me and my Uncle Wade Smith and Mr. Neiman and yourself. We had a status conference regarding the case to talk generally about the case. And at that time, scheduling was discussed. As far as, for example, the filing of pretrial motions and today's date to be heard on the pretrial motions. In addition, a trial date was set at that time for October the 3rd. And I don't know if Your Honor recalls, when we started talking about, at that point in time, keep in mind, we had the completed discovery in the case for less than a month. And at that time, I was jittery or nervous, whatever you want to use, about even setting a trial date that early on when we had just gotten discovery in the case. I don't know if you recall that or not, but anyway, I can certainly tell you that I was very wary of setting a trial date at all for the October 3rd setting. Since then, we have been working as hard as we can on the case. We have retained 3 experts, 2 very recently. And this is, well, let me start at the beginning. Accident reconstruction specialists, Mike Sutton and John Flanagan. They've been involved in the case for some time and are actively involved in the case. We've also hired Dr. George Corvin, who has begun work on the case, and we have hired a Dr. Wilkie Wilson that is more of the subject of this motion to continue, and I know, and I'll comment on some of this in a little bit. Mr. Neiman is going to talk about Dr. Wilkie Wilson at the appropriate time. Again, they have all been retained and have begun working on this case. Dr. Wilkie Wilson is a neuropharmacologist at Duke University. I first became aware of Dr. Wilson, well, 2 ways. But first became aware of him through, I don't know if Your Honor has seen the Talk It Out campaign or program, however you want to word it. It's a state-supported, sponsored program through the ABC Commission, and that's when I first became aware of who he was. He's very big in their most recent campaign that focuses on adolescents underage drinking, the differences in the adolescent brain, and I hope this is okay, I'm just giving you a little background, Your Honor. So I first became aware of him. He has again, he's a pharmacologist, a neuropharmacologist. I first became aware of him through the Talk It Out program, and him dealing with adolescents and how an adolescent brain, the effects of alcohol and drugs affect the adolescent brain differently than an adult brain. I also became aware of Dr. Wilkie Wilson, and just doing some research in other cases. He was hired by the defense in the State v. Graybill case, which was also an Orange County case. I can't remember the date of that, but a few years ago, it was also a second-degree murder case involving 3 deceased victims. So I noticed him in those 2 areas, and of course reached out to him. He and I had conversations on the phone, and then I'm trying to do the dates the right way. We met last Tuesday at our office where he agreed to serve as an expert in our case. And again, he's begun work. It immediately became apparent from my first face-to-face meeting with him that he had been working on a 2011 death penalty case in Harnett County, and that I'm not seeing, it's Christopher Brackett, State v. Christopher Brackett. I don't have a file number. I can easily find that, but in any event. He immediately noticed he had a conflict in that case. That's a 2011 case. He has been subpoenaed for that case in Harnett County. That's attached to the motion. And it appears that if that case goes to trial, the other attorneys for the Center for Death Penalty Litigation, they hope to resolve that case, but it's a 2011 case and it's got a trial setting for, I believe, 9/26, the subpoena says. Now, that is the basis for our motion to continue, specifically the Dr. Wilkie Wilson, what appears to be a direct conflict at this time for our case, which is a 2015 case, that being a 2011 death penalty case. Now, I want to bring something to the court's attention, which Mr. Neiman brought to my attention this morning, sitting over in the jury box. Apparently, I accidentally sent him an email last Friday, August the 12th. He didn't let me know about this until this morning, but I accidentally sent him an email, and it had an email strain of correspondence between me and Dr. Wilson and the attorneys on that death penalty case, and it becomes apparent from those. I'm not going to read them off to you. I don't know if Mr. Neiman plans on doing that or not, but I wanted to make the court aware of this. It was accidentally sent to Mr. Neiman, as well as other attorneys that are, of course, working on the case. What is apparent from these emails, nonetheless, is though Dr. Wilson noticed that there was a conflict on these cases and began to get a subpoena for that case, and the other attorneys wanted him to be subpoenaed on that case because it's a 2011 death penalty case. I'm sure Mr. Neiman is going to get into those emails in more detail. It's embarrassing as an attorney to have that happen, but I made a mistake and I hit Jeff probably instead of James. Nonetheless, Your Honor, also on our motion to continue, my understanding of the caseload here in Orange County, when the case was set for trial October 3rd, at least there appeared to be much older cases ahead of this one. What we've tried to do is time this motion to continue on today's motion date and let the state know as soon as we could that we were going to ask for a motion to continue. So people haven't been subpoenaed, made travel plans, made hotel arrangements. So we're not doing this to needlessly delay a case, not by any means whatsoever. We have a lot more work that needs to be done. We have an apparent conflict with Dr. Wilson on the case, and we wanted to let the state know and, of course, ask the court for more time to prepare on this as soon as we could. Thank you for letting me be heard.
All right.
I would ask that you grant the motion to continue.
Okay. I just want to make sure I have the timing right. The Harnett death penalty case is September 29th or 26th, something like that?
By memory, I thought it was the 26th, Your Honor.
26th, okay. So this trial could be done before they finish picking a jury? I mean, it's gonna take them 2 or 3 weeks to pick a jury, right?
I don't know how long it will take them to pick a jury. I imagine it's going to take us a while to pick a jury too, with all due respect, Your Honor, in a case that involves this much publicity, of course.
Okay, but, I mean, we can agree that a death penalty case is gonna take longer.
Sure. Oh, yes, sir. Yes, sir.
Okay. And
And I
this,
understand your question on that.
well, I'm just trying to figure out if the timing really is intersecting or not, and then is the forecast that your witness would be a day, 2 days of evidence? I mean, I don't, cannot.
We don't, well, first of all, at this stage, we don't know exactly who we would be calling as witnesses. Certainly, his testimony is critical to the case, we believe, and he would be called as a witness. How long would his testimony take? I'm not trying to dodge the question.
No, I
I'm
know.
not sure.
I mean,
I'm just
of
not
course,
sure.
the question for me is, can these proceed? I mean, it's not you that's affected, it's one witness over the course of a couple of weeks here, probably, and probably twice as long there. And so, we're not saying the attorneys can't be in 2 places. We're talking about one witness who's gonna have a narrow slice of concern in Orange and in Harnett.
I understand your point, but that
It's not a
assumes
point,
that-
it's a question.
Okay.
I'm asked, I mean, that's what I'm hearing. I'm not hearing anything other than that as a basis for the motion to continue.
That would depend on if the attorneys in the death penalty case need him in court to hear testimony from other witnesses as an expert. That's a possibility. We may have the same possibility here. We would want him as an expert to hear the testimony regarding a blood draw, for example.
I thought he was about effects of,
Well, alcohol, he would be about effects of alcohol, but he does more than just that. That was the first time I honed in on him when I heard adolescence and alcohol.
okay.
If that makes sense.
Yep. Thank you.
Yes, sir.
Okay. Mr. Neiman? And I'm sorry. So when were you asking to continue it to?
I did not have a date in mind on that. I assumed that we would need to discuss that.
Okay. All right.
Your Honor, I just want to highlight a couple of facts and not intentionally reiterate all of them, but full discovery, and when I say full discovery, I'm not denying there have been certain conversations that have happened, but as far as the bulk of the discovery of this case was made at roughly a month in advance of the date that we set this trial date. And so that was a date that we met, and the purpose for this court, I believe, was so that both parties can plan accordingly to try these cases. That was set in March, giving both sides about 6 months to prepare. I am not aware of any reason why the attorneys in this case would not become aware of Dr. Wilson's necessity, and I'll touch on that in a moment, until August 10th. August 10th is the date that I received first informal notice formal notice. I did receive formal notice that they intended to call Dr. Wilson. And the timeline is important here, Your Honor, and that's where the email comes in, I would say. What I'll say as a threshold point is, at this point, the state just by email in the last couple days has received a CV for Dr. Wilson, has received no report from Dr. Wilson. We don't have any idea what his opinion is going to be, and the reason that's important is, one, we're entitled to notice of that, and two, neither the state nor the court can decide. We can't decide if we're going to contend, or the court can't decide if it will agree that he has any relevant testimony to this trial whatsoever. Now, I'll concede that if that were the only issue, the court might determine later that his testimony is relevant, and then we'd just be back here talking about whether it needs to be continued, and I get that. But I will say today, the court's not been given any reason to believe that he has relevant testimony to this trial. He's certainly not a witness to any of the events of the case. He may have an expert opinion. I will touch on that today is the first day I'm hearing about this Dr. George Corvin. I don't know and if I can be corrected on this, that he's been included in any of the notice that I've received up until now. As far as when they became aware that they wanted or needed Dr. Wilson, here's what I'll say. On July 31st of this year, I met with Sam Coleman, who is one of the attorneys who has made a general appearance in this case, in which we discussed, among many things, the work of the Talk It Out program, which is being referenced here. I can't say for sure Dr. Wilson's name was mentioned, but it seems only logical that at the point that I'm hearing about this program in discussions about the case, that it's because they're aware of Dr. Wilson and what he does. I wasn't noticed at that point that they needed this witness, but I think it's easy to conclude that at that point they could have identified, even though that was 6 months after the trial date, or 4.5 months after the trial date was set, that they may have had a good reason to know that they wanted them as a witness. In the alternative, I will say that on August 10th, they made it publicly known in the form of a motion that they wanted Dr. Wilson as a witness. And I do want to proffer this email thread to the court, Your Honor. I have a copy for defense. And would you like for me to mark it as an exhibit?
Can you all approach?
Yes, sir. Sure. Without actually putting it in evidence?
Or referencing it?
I guess I could tell you what I think the point's going to be. You can tell me if you agree. My point is that they noticed that they intended to call this witness on the 10th, but he's not subpoenaed for the case until the 12th. And the email specifically references that they have face-to-face meetings with this person. If they wanted to subpoena him, yeah, you have an opportunity to be first in time to subpoena him. That's the point I'm making. If you want me to just argue that.
Sorry, why is there a rule that says the first one is subpoena gets them?
I don't know.
I don't think there
But
is. I mean, if I demand that he come and there's some district court case, I don't play that game, but there's some district court case that's got, I had him under subpoena before. I think most people are going to get him here first. I don't think that's a good job. So,
I mean, I think that the relevance of the email speaks for itself if you read them, but.
well, you know, this is a matter of professional. You can assert that's fictional.
Until today, I would argue just the intention is that they're just quoting right here, just so you know, this is back in what we talked about. I did not realize it until I thought about it. He said, no, that was a mistake, so I'm not trying to take every argument that was in the script.
Well, this just seems like if you want to argue.
So, Your Honor, what I would contend is that they were aware at the very least of their necessity to have this witness and desire to have this witness on August 10th at the very latest, because that's when they noticed the state of their intent to call him. He's not subpoenaed for the other case until August 11th. While being first in time on the subpoena may not be controlling, it certainly does go to the idea of whether or not this is truly a conflict or the hope of a conflict. And I would contend there's some reason to believe that it's advantageous that there's a conflict, perhaps. And my bottom line argument is this: there's not a conflict, and here's why. One, the set trial date that I'm aware of, based upon checking nccourts.org and conferring with the prosecutor in that case, is this case is set to go to trial on September 6th. Now,
This case meaning the Harnett.
sorry, the Harnett County
Right.
case, excuse me, the conflictual case.
Yep.
Now, I suspect that the parties expect jury selection to go so long. That is why the subpoena that was issued does not go until September 26th. But I would say that it certainly goes to the idea that this is not a witness that they expect to be here as a consultant for the entirety of the trial if they're not subpoenaing him until the 20 days after the trial's set to start. Second, the subpoena says, do you have the subpoena in the motion before the court? Should be as
It should be attached.
Exhibit B attached to the motion.
Yes, I do.
It says witness shall be put on telephone standby. That does not seem to support the contention that this is a witness they intend to have to be there as some kind of full trial consultant. He can be put on telephone standby here too, Judge. The trial is set to start almost a full month before this trial is set to start, and his testimony, I guess, is estimated to start a full 1 week, before this trial is set to start. Furthermore, conferring with the prosecutor in that case, and I have to be candid, Your Honor, I can't call his name right now. I'll just convey to the court I'm confident. I checked with the Harnett County DA's office, and they referred me to a gentleman, and we had a phone conversation. He said he's not been noticed by the defense of any intention to call Dr. Wilson as a witness. And that's not the end of the conversation, but it also goes to how serious this conflict is. He did say, in looking back over some pretrial paperwork they'd received, that he's mentioned in a document having to do with plea negotiations, but he's not received actual notice of their intent to call him as a witness. I spoke to him about whether he would say the same thing I would say to this court, is that we as the state, obviously within the discretion of the court and reasonableness, will make every accommodation necessary to make sure that if Dr. Wilson has a conflict in Harnett County, if it means we have to carry over, if it's towards the end of a day, carry over to the next day, so with some reasonable accommodations can be made and no objection from the state if it's necessary to make him aware or make him available. And the prosecutor over there said that he would definitely say the same thing over there. No objection to reasonable accommodations to avoid an actual conflict. I don't know how many witnesses the state or the defense intends to call. I have an idea of how many witnesses the state intends to call, and I suspect it will be substantially more. We intend to send out subpoenas this week, but to be sure that we wouldn't be coming back to the court saying we've got a witness availability, I actually called all the essential witnesses of which I'm aware right now to be sure of their availability. And I'll say I have one witness who, one of the troopers you heard from today, already has family vacations out of the state, but he'll be able to be here for this, what would be potentially the second week of the trial. And I said I can work with that, given my expectation, but I don't think that that's a reason to continue the case. Another of the troopers that you heard today was accepted into an advanced training course at North Carolina State University for this fall that would actually mean he would be taking 4 months off being an active trooper and be the equivalent of a full-time student at NC State during the fall semester. In anticipation of the fact that this case is going to trial, he had to forego that with the hopes he might get into it at a future date, but pulled himself out of that class because we knew from March that this case was set to be tried in October. Again, not saying that one fact alone is controlling, but it's just showing that we are doing what we can to make sure we do make our witnesses available for the trial that was set 5 months ago. And given that, we have nothing before the court today that proves that he has relevant testimony. We certainly don't have anything before the court today, I would say, that shows there's a true conflict. I would contend that this is something that we can work with. I realize the consequences to the state's case at further levels of review if somehow the defense is not able to present their defense as they proffer it to be. And I wouldn't seek to avoid that. But what's been presented to the court is nowhere near enough to say they wouldn't be able to do that. They will be able to do that. And I would ask you to say that this trial date that is set for October 3rd be kept, we move forward, and we proceed with the case.
Right. Okay, I'm gonna deny the motion to continue. I just feel like it's a narrow enough issue and easily addressed, and it's sort of what we do all day, every day, is manage caseload and manage witnesses, and I think we can do it in this case too. So, I'll deny that motion.
Yes, sir.
Thank you, Your Honor. I confer with Mr. Smith before. I think we agree that those are the matters relating to this case to be addressed by the court today.
Okay.
Do you have an idea at all about when you might be?
I will rule this week. I will invite, well, I'll ask you all if you'll consent to this, but I would invite any further submissions in writing on the issue of essentially the issue around when the search warrant was executed. The Orange County, other trooper signing it, sort of based on the Randolph County. That, you understand the issue. I'm not gonna try to capture it. But if, we talked about some, my question about the subjective belief of the officer as indicated by the writing versus the court's legal conclusion. And so I'm going to do my own research, but I'll certainly invite that. If you all are okay with that.
Certainly.
Is that,
Court.
you all could do, find something or determine you can't find anything on point, share it with each other, and then submit it to me. And if you all want me to delay ruling until I get that, I will. If you want to get it within a couple of days, I can keep my promise of ruling this week. But
Do you have a time frame, Your Honor?
I mean, I was
that you're thinking
intending to rule this week, which would mean you would need to get something to me in the next couple of days. But if you don't want me to rule this week because you need more time, that's also fine. This week was my self-imposed deadline. But I'm happy to wait till next week. If you all want to the end of the week, for example, then I can rule next week.
I think that I'll either know that I have something to submit or not by Thursday at the latest, which means, so my position is you can still rule by the end of the week. If you haven't gotten something from me, it means I don't have something to give you more.
Okay.
We'll work as hard as we can to meet that deadline. If we're having a problem, we'll reach out to you both.
Okay. Fair enough. So let's just say that the ruling will come after that, whenever that is. And can I just ask you all to communicate amongst yourselves before you submit anything to me, and then figure out the way that you think is appropriate to get it to me, or email's fine, but just make sure everyone's playing under the same rules.
Yes, sir.
Yes, Your Honor.
Thank you.
Thank you.
All right. Thank you all. Appreciate it.
Thank you, Your Honor.
Thank you. Good to see you all.
Good to see you.
So, are there any other, do we need to set another court date before the trial date?
I'm aware. Well, I guess maybe it is worth your consideration or the trial judge's consideration if those other motions that the trial judge should decide I would think they're the kind that can be handled either on Monday of the trial week or during the trial, is my feeling on it, but.
Trying to remember what they were, but I think that's probably fine. So why don't we just say, we'll continue the case to October 3rd. All right, thank you.
Thank you.
Excuse me, over Channel 3.